context of this message, this individual is reaching out, asking if Mr. Demmons is good after he's been tagged in multiple social media posts about this drive-through, this shooting. And Mr. Demmons responds very succinctly, "I did that." Shh.
All right, Professor, how do you fight back against that?
Well, that's hard to fight against because that is almost a summary of the prior evidence. The prior evidence is all circumstantial. And here you have a statement, a direct statement. It's ambiguous, to be sure. And if the statement alone were introduced into evidence, it could be interpreted in multiple ways. And remember, too, that proof beyond a reasonable doubt doesn't require that each piece of evidence establish guilt beyond a reasonable doubt. This wouldn't do that. It requires that the evidence all taken together proves beyond a reasonable doubt. And if I'm the prosecutor, I use that. It's not a confession by any means. It's a misnomer to call it a confession. Use that piece of evidence which may constitute something close to an admission, not a confession, something that could be interpreted as incriminating. And I would use that to tie together the other circumstantial evidence. And, you know, when you get evidence from the mouth, pen, or email of somebody themselves, it's far more compelling than evidence directed against them by other people. This really does put also a burden on the defendant to explain. And that's one thing as a defense attorney you never want, because that may incline the jury to say, gee, this is something he could explain. Let's hear from him. And if he doesn't take the stand, obviously, that can be, although the jury is instructed never to infer guilt from the failure to take the stand, that could, taken together with everything else, become an important piece of evidence.
I feel as well that the defense has to explain that. And I don't know how they explain it unless they call an expert in something to talk about social media. And maybe he's just, you know, maybe this is all bluster, or maybe he's joking. I have no clue. So how do you explain that if you don't want your client taking the stand?
Very difficult. I would not put an expert on. If you put an expert on, it just highlights the fact, what do you need an expert? Why don't you put the defendant on the stand to explain? What do you need a third party to explain? So I would not put an expert on. I would either, if you could, and the facts, I don't know enough about the facts to know whether there's any possibility of putting a defendant on the stand. But if not, I think then the burden falls to the defense lawyer to try to offer an explanation, which you're entitled to do in closing argument. And so, but it's risky. It's risky. There's no perfect way of responding to a piece of evidence like that. You know, there's an old stuffed fish experience when people have a stuffed fish on their mantle, and the plaque says, "I'd still be swimming if I had only kept my mouth shut." And I'm sure the defense attorney is saying that right now. If only he hadn't written that on social media. If he hadn't said that, in that case, it's not your mouth shut, it's your, you know, obviously social media. But that is damning. It's not by itself conclusive, and that's why it's not a confession. But taken together with other circumstantial evidence, it could help put context, as the prosecutor said it, put context on the other evidence.